Mr. Brons is next.
Have very little in common with extradition hearings that preceded the 2003 Act. Even at the main hearing, the court does not consider the evidence, but only 10 so called legal bars to surrender. Lack of evidence is no bar to extradition. Even people accused of behaviour that is not an offence in the extraditing country can be surrendered under the European arrest warrant if the offence is one for which there is no requirement for dual criminality. Whilst most of these are serious violent, sexual or dishonesty offences, the list also includes the nebulous thought crime offences beloved in so many continental countries, so that the arrested person can be sent for trial, or rather automatic conviction, to one of those wretched places. The fact that such warrants are issued for the purpose of prosecuting a person on the grounds of his political opinions ought to constitute a legal bar to surrender, but I suspect that some political opinions would be less equal than others. We were sold the European arrest warrant on the promise that it would be used to send terrorists to justice, but the miscarriages of justice in the case of Gary Mann, Deborah Dark, Edmund Arapi and Andrew Simeo and many others had no terrorist element at all. Worst of all have been the cases of people being extradited for questioning without a charge having been made. We must reinstate the requirement that a court will extradite a person only when there is compelling evidence that a serious offence under the extraditing country's laws has been committed. Thank you.
Thank you, Mr. Brons.